picking up where I left off, we said that the court has basically said that in their in their battle to figure out how to manage public right to order and individuals' right to assemble, that their compromise has been that you are, or city governments and mayors are allowed to place limitations on where, when, and how you are allowed to assemble. And so, for example, I can say, hey, if you want to protest outside of a Planned Parenthood clinic, you can do so so long as you are 300 yards away from their entrance. So you're not intimidating and harassing people going in, right? My forcing you to move 300 yards is not limiting or not nullifying your right to assemble. It's simply saying you have to do it over there. Or if you want to take out there's going to be a big rally for neo Nazis in downtown Colorado Springs, the city might say, fine, you can do it, but it has to be 6 months from now on a Tuesday at 2 o'clock. That way we can get the appropriate number of police officers there to keep peace, and it won't dramatically impede the city's function. And so, permits and deposits, yes. The only thing is once they grant the permanent deposit and they know what you're going to basically, how you're going to do it, then they can't restrict what you're going to say while during your thing. So, if you're going to apply for a permit to do a neo-Nazi rally and they say, good, 6 months from now, Tuesday at 2 o'clock, they then can't arrest you on that Tuesday at 2 o'clock for saying something that they feel is out of line. And so basically that has been their approach. This was defined in American Nazi Party v. Illinois that tried to prevent the American Nazi Party from holding a rally. We also, have seen that the court has generally been sympathetic to businesses, organizations who feel that protesters, basically their protesting is hurting their business or harassing their customers. And so, for example, like I gave you the abortion clinic, right? Basically, they've said, yes, people have a right to protest the abortion clinic, but it must be a certain distance away. We also tend to see that the right to assemble has been interpreted as that people also have a right to associate with whom they would like to, and in what ways they want to. This basic freedom to associate with like-minded people, protected by the form of right to assemble, has been the whole constitutional law foundation of interest groups. We saw an NAACP v. Alabama, where Alabama sued in the Civil Rights era to get the membership list for the NAACP while they were pursuing some sort of phony, trumped up charges. And the NAACP, the National Association for the Advancement of Colored People, this is an interest group dedicated to furthering the rights and power of African Americans. The NAACP refused and said, we can't turn over that information to you because you will use it to harass us. And the court found in favor of NAACP and said, you're right. You do not have to turn over your membership rolls to the state of Alabama because people have a right to associate. So now let's take a look at the Second Amendment. We've gone through the First Amendment, the right to assemble, the freedom of religion, right? Freedom of speech. Let's talk about the Second Amendment, another hotly contested and very controversial civil liberty. What we have basically seen, and I told you this earlier, that the Supreme Court tends to not like to take on cases that they know will be super divisive in the American society. And so over the course of our country's history, particularly for the last 100 years, the Supreme Court has generally avoided issuing writs of certiorari for Second Amendment cases. If you remember, writs of certiorari are when 4 judges agree to take a case, they issue a writ of certiorari, and that case is heard in front of the Supreme Court. And so the Supreme Court has largely steered clear of Second Amendment cases because of how controversial and divisive they are. And if you remember again, that the court does that so as not to be even appearing to the general public like they're wading in partisan politics. The court generally wants Congress to figure that out. But we have seen recently that the court has been more inclined to take on Second Amendment cases. This trend started back in the 1990s in the case of DC v. Heller, the District of Columbia v. Heller. In this case, Washington, D.C. Sued a guy by the name of Heller because they had recently passed a law in city government in District of Columbia that handguns were illegal. Yeah, if you still wanted to have, a shotgun or a hunting rifle, you were allowed, but handguns that DC was arguing was being used in significant amounts of gang violence crimes, and the death rate or the murder rate in DC at that time was through the roof. And so DC banned handguns within city limits. Heller sued, DC sued Heller to get his handgun. And basically, the court found in that case that they couldn't, right? The District of Columbia could not ban access, blanket access to handguns. Unlike where Ronald Reagan banned access to automatic machine guns, handguns were not seen by the court as woefully destructive, and therefore District of Columbia could not limit a person's Second Amendment right to carry that particular arm. Now, you would think at that point that decision would have incorporated the Second Amendment at the state level, but I want to give you a second to pause and think about this. Why did that decision not restrict other states from banning handguns similarly? Because Illinois tried to do it shortly a couple years later. I'll give you a hint. What is DC? If you said that DC was basically the District of Columbia wasn't a state, and therefore DC is managed by the federal government, and so when DC v. Heller said the federal government can't restrict access to handguns, it didn't necessarily say anything about the state. So DC v. Heller didn't incorporate the Second Amendment at the state level, but that did happen shortly later in McDonald v. Chicago. In this case, McDonald, a private citizen, sued the city of Chicago, who was trying to ban handguns of themselves. And the court basically there's that incorporation case, the 14th Amendment, used the due process clause and the equal protection clause to say that citizens living in Illinois couldn't be restricted of their civil liberties any more than citizens of Ohio or Michigan or Wisconsin or Pennsylvania. Just because a person lives somewhere doesn't mean their rights can be limited. And so DC v. Heller was not an incorporation case, but McDonald v. Chicago was. And if you remember, incorporation is the doctrine where the court basically takes a federal civil liberty and mandates its application at the state level. Now, even though the Second Amendment was incorporated at the state level under McDonald v. Chicago, we need to be clear here that the right to bear arms is not unlimited, just like there are limitations on certain types of speech or certain types of freedom of press or the rights to assemble. The court has defined what are the boundaries of the right to bear arms. It has allowed states to restrict concealed weapons, that is not federally not protected under the Second Amendment's right to bear arms. That yes, you have a right to bear arms, but you don't have this constitutional right to do so secretly. Some states allow it, some states don't, and the states that don't are allowed to not do that. We've also been allowed at the federal level and the state level to restrict access to guns to convicted felons or people who are mentally ill. That is a limit, right? The state or the government can seize weapons hauls from people who are seen as, schizophrenic or, or convicted of murder and now out of prison. So that is a limitation that you could restrict somebody's Second Amendment. There is also certain protections that the court has generally been sympathetic to that would allow restricting carrying of these weapons in specific places. So, for example, the El Paso or Pikes Peak Library District prevents open carry, so people cannot bring guns into the library. The same way, on school zones, you can't have guns in a school zone. And so, even though the Second Amendment guarantees you the right to bear arms, the court has said not everywhere in every time that certain states and local governments can restrict, and businesses are within their rights to limit that right to bear arms. And then they've also generally found that if the government, state or federal, can make a case that certain weapons are dangerous and unusual weapons, that they would then not be protected by the Second Amendment. So, the sexiest example would be like rocket launchers, right? You can't go out and buy a rocket launcher and then argue that you're allowed to have it because the Second Amendment guarantees you the right to bear arms, right? Handguns, sure. A semi-automatic rifle, yes. But what about an assault weapon? That's in the news today as people discuss, can we restrict that? Ronald Reagan, as I said earlier, famously restricted persons' rights to purchase automatic weapons, so like basically machine guns. That has been upheld by the court as well within boundaries of limiting the Second Amendment. So now let's take a look at the question, what rights do defendants have according to the Bill of Rights, right? So let's be specific about if you are accused of a crime, if you are charged with something, or let's say you're stopped by the police. What rights do you have to protect you from maybe an overzealous or discriminating government? And so when we look here, you can see that a substantial number of the Bill of Rights pieces, the amendments in the Bill of Rights, are dealing with the rights of people accused of crimes. I mean, it's literally like, I think 5 through 8 or something like that, all has to do with, a right to a fair trial, a right to a speedy trial, double jeopardy crimes. And so we've looked at that, and basically you see, again, the context that prior to the creation of the Bill of Rights, fresh on people's minds were the abuses of King George, who were locking people up without extending habeas corpus rights, or trying them in one court, and then when that court found them non guilty, trying them again, right? And so the abuses of the British made the authors of the Bill of Rights amendments especially careful to include quite a few protections by defendants and giving them rights. And so I said the 5th through the 8th, actually the 4th through the 8th. The 4th, 5th, 6th, 7th, and 8th amendments all deal with our court system and specifically defendants, right? And so at this point, most, but not all, of these rights have been incorporated at the state level. You're going to ask me right now which one hasn't, and I'm blanking on it, but I'm quite sure I'll report back to you later. Let's take a look specifically at the 4th Amendment, which is that people have a right to not have the government knock on their door and say, I want to search your house. If they did that, you would be well within your rights to say, fine, you can, but you better get that's right, a warrant, right? That people are protected from unreasonable search and seizure. Now, the word unreasonable is obviously the vague one that the court has needed to kind of clarify. What is considered an unreasonable search or seizure? Or what would be the qualifications for something to be a reasonable search and seizure? And so, quite simply, everything you've seen on Law and Order and those shows, for the most part, is pretty accurate. That police must establish probable cause in order to search your premises or arrest you. They can't just come up and say, well, you look guilty, so we're taking you in for questioning, right? There has to be an argument you have to have probable cause to search. That has been the threshold. That you use probable cause to get a warrant, right? And so, if I am, as a police officer, want to search a person's house, I have to contact the judge. I have to make my case to the judge of here's why I want to search this person's property. And the judge has to sign off that says, I buy your argument. Here, I grant you probable cause. Go ahead and search that person's house. We are going to pick up here at the end of this is episode 5. We will probably finish this lecture in the next episode. Have a great weekend, you guys.